Hello to everyone. Happy holidays. I'm hearing this loud music outside the office, and I think it's the sounds coming from Herald Square from Macy's. So I think some holiday shopping must be happening out there. So we're going to be talking about estate planning for the new year. And it's really a review, as I see it, of what has happened in 2020 and what obviously a lot, and how that might change some of the plans you have, or might be just a reminder to continue your planning if you have, or to start your planning if you haven't yet done so. So I want to start by doing a review of what I think are the main topics and changes that have happened in the past 12 to 13 months that have really led for those who've already done planning to review that planning, and for others to hurry up and get their planning done so they have changes. I would say that one of the changes is that we had an election and that a new president will be starting in January. And I don't know yet what that's going to mean. So I know we talked about a Biden presidency, and as we discuss different topics today, I will go through what potential changes may happen with a change in administration. However, as we all know, we have a multifaceted government. Our government has multiple layers to it. It has different branches, and the different branches of government really have to come together to change the laws. And so having a new president may change the direction or the proposals that are brought up, but it doesn't necessarily change law. And so while we know that that's something to watch moving forward, there aren't a ton of action items for most people based on the new president. The things that I really look at as being most important, I want to go back to almost exactly a year ago, the end of December 2019, we had something called the Secure Act, which was signed into law. This was a federal law that changed the scheme for retirement accounts. It changed a few different things about retirement accounts. Some of the main changes that affect most of our clients and most of the people that we're talking to is, one, if you were not yet 70 and a half years old and not yet taking those required minimum distributions from any tax-deferred retirement accounts, you now don't have to take that distribution until you're 72. So it delayed the age in which you need to take that distribution. It set up new rules for small business owners having retirement accounts for employees. It changed, most importantly, the payout rule for beneficiaries. So it used to be that if a mother left her daughter a $100,000 IRA at her death, the daughter was the named beneficiary, that the daughter could roll that over into an inherited IRA and get what we call a stretch. The stretch means that the daughter could take that distribution over her life expectancy. And the IRS has a table with the life expectancy on it. And the daughter, if she was 50 years old when her mom passed, maybe had 40 something years that she would have to take that account out. And that's how they would determine what her required minimum distribution was upon her mother's death. This is the big change in the Secure Act. The daughter in my example, unless she falls into one of the exempt categories, that daughter would have to take that distribution, a full distribution of that $100,000 account in 10 years. Now that's tax deferred income. So that means that this daughter, who may have only had to take a very little bit out each year as taxable income and could leave that growing tax deferred, now has to take a full distribution of that account within 10 years, giving her more taxable income. So it potentially raises her taxes, could even bump her into a different tax bracket, but also makes it so that that can't continue to grow tax deferred over her lifetime. So what this means for planning is that people just have to take a review. Now, everything I'm going to talk about today, all of these changes, it doesn't none of these necessarily mean there's a change that has to be made. It's just more reason that at the beginning of the year or at the end of this year, whenever you get around to it, you should be meeting with your attorney to review what you have and to talk about how these changes may impact your plan. This is going to be very different from person to person. And so you're really going to want to get personal legal advice as to how this is going to affect you. So step one is the Secure Act. That was a big change. That got overshadowed by COVID. COVID was a big change for us estate planners. What we learned from COVID was that courts can shut down and inefficiencies can get worse when you don't have access to the courts the way that we're used to. Now, my hope would be that all of us, including the court system, has learned valuable lessons from the COVID-19 shutdowns that have occurred and are working to fix those inefficiencies, and a lot of them they have. And that if this ever should happen again on this scale or a smaller scale, that we wouldn't have these same inefficiencies or these same lags with the states. But COVID really did make it very difficult to probate a will, to do an administration process for somebody who died without a will. And from that, many of our clients have moved towards other planning to avoid probate. And we're going to talk about that today. But COVID's another one of those things that taught us something in 2020 about how we talk about our estate planning. It also, the other thing, in addition to dealing with after death issues with COVID, but COVID showed us the importance of having those advanced directives, those healthcare proxies, powers of attorney. What if you are quarantined or isolated or in the hospital and unable to handle your own affairs? Have you named somebody who can step in for you for that time period when you can't do it? And this is very important as well. Another big change that happened was that when the budget was signed in New York State at the beginning of April of 2020, there were massive changes to the home care Medicaid or community Medicaid structure. The biggest change that got headlines is that they put a 2.5-year look back into the home care Medicaid program. This means that if you are applying for Medicaid services in the home, for a home health aide to come assist you, that any transfer of assets made for 2.5 years before that application, the immediate 2.5 years before that application, could create an issue. And so again, this is just more reason why people should be reviewing their plans and potentially doing more advanced planning, because it used to be that we could transfer assets in August and apply in September for care. And that's not going to be so simple anymore. And so you're going to want to change that and potentially change your planning. The other big change in the Medicaid regime was the way they're going to assess for home care. So the way they're going to assess how many hours of care and what the care plan will be for an individual. Now, there's not a lot of estate planning we can do to prepare for that. But one of the things that we know that the assessments, the change in the assessments will do is it will make it so that those with low level needs won't be able to receive care through the Managed Long-Term Care Medicaid program. And the result of that is going to be that there might be some more out of pocket for people on the front end when they have a low level of care. And so to the extent that people can use their assets and plan for that time period where they might not be able to get that extensive care because now the threshold is higher to qualify for care, you're going to want to have that planning in place as well. So again, there's no magical answer to any of these questions that would apply to everybody listening here today. But there is one answer which you should be hearing over and over again, which is that you should be speaking with your attorney, speaking with your financial advisor, speaking with your accountant, figuring out if there are changes that you can make and what those changes might be. And as we say, you should be planning, you should be replanning, and you should be planning again. Estate planning is not a one and done thing. It is something that is done multiple times, a process that is engaged in multiple times throughout a person's life. And as changes happen, the plan should be revisited. And we usually say that you should review your estate plan when there's a change in your life or in the outside world. So for yourself, if there's a death, a birth, a retirement, selling the home that you've lived in for 40 years, these big changes, moving states, that's when it's important to have your plan reviewed. Also, a change in the law. We've already talked about a few. So I would usually give all the reasons and all the times when you should review your estate plan, but the answer is you should be reviewing it now, because all of these things are changing in our world, and we want to make sure that everybody is properly planned for. The other marker we use for people is to redo or revisit your estate plan every 5 years and just have a review of that estate plan. But again, there have been these big changes even within the last 13 months that I would say means that you should really be reviewing your plan now with your attorney. So those are the big changes that have happened. Now, right before I got on this webinar today, I got an email from New York State Assembly. I'm on an alerts list, and there's a power of attorney law that has been backed by the New York State Bar Association and the New York City Bar Association to change the current power of attorney law in New York State to make it a more user-friendly document and to change certain provisions within the general obligations law, which covers power of attorney. That law passed our legislature over the summer, and as of just a few minutes before I got on this webinar, my email came in that that law was delivered to the governor. So it's very possible that in the next 10 days, that law is going to be signed by the governor. And that's just going to be one more reason that you should be reviewing your estate plan and seeing if there's changes that need to be made in light of this new law. So all that being said, those are all of the reasons that you should be looking into changing or reviewing your plan. But I want to talk a little bit about the different documents that we review with people when we go through their plan and some of the basics of those documents, especially for those of you who have not engaged in this type of planning yet. So first, I want to talk about advance directives. Advance directives are healthcare documents, healthcare related documents that talk about your wishes for your care if you are unable to speak for yourself. So they're called advance directives because you sign them in advance of needing them while you still have the capacity to do so. With all the documents that we're going to talk about today, but most specifically with the healthcare documents, I always advise people that not only should you be seeking the advice of an attorney, figuring out what you want to go in the documents, properly executing the documents, but you should then be having conversations with your loved ones and the people that you've chosen to serve as your agent so that they know what you would want them to do. That makes their job easier when they have to do it because they understand through these conversations what is most important to you and what do you want to make sure happens. So an advance directives are a healthcare proxy, living will. We often sign a HIPAA release form, and I'm going to talk about a MULST form. A healthcare proxy is a document that says who will make medical decisions for you if you are deemed incapacitated by a doctor. A healthcare proxy needs 2 witnesses over the age of 18, and they should not be the persons that you've named in the document as your agent. This does not have to be signed with a lawyer. As you heard me say, it does not need a notary. It just needs 2 witnesses. This document will name 1 person at a time. That's very important. So if you have 2 children, you can't say child 1 and child 2 will serve as co-agents. It needs to be 1 and then the next, 1 at a time. You'll give their name, their address, their phone number, so that they can be reached in case of an emergency. You want to make sure specifically that this document says that your agent knows your wishes regarding end-of-life treatment, artificial nutrition, and hydration. As I just mentioned, you want to have these conversations with your agent so they know what you would want them to do. The document, if you have the New York State Department of Health healthcare proxy form, it's a 2-page form, and on the front of often it's double-sided, and on the front or on the first page, there's a section that actually leaves blank for you to write in that your agent knows your wishes regarding artificial nutrition and hydration, and you should be filling out that section so it's clear that they can make those decisions for you. You can also talk about organ and tissue donation on this document, and you can put a limited duration on the effectiveness of the document if you want. For most of our clients, they sign a healthcare proxy and it's in effect indefinitely unless or until they die or revoke it specifically. The next document is a living will. A living will is a document that says your wishes if you were to be in an irreversible state with no reasonable expectation of recovery as determined by a doctor. And we like to make sure that the document says that if that is the case, that your agent, referring back to your healthcare proxy, knows your wishes and can make decisions for you regarding these types of treatments. Some types of treatments that are often talked about in this document is cardiopulmonary resuscitation, CPR, if you need to be revived. It talks about kidney dialysis. It can talk about antibiotics. It can talk about cancer treatments, blood transfusions, all sorts of feeding tube, hydration, all sorts of measures that are taken to keep people alive. And very often people sign this document to say that while they want to be kept comfortable and out of pain, that they don't want their life to be prolonged by these means if there's no meaningful expectation of recovery or of a meaningful recovery. The next form I referred to is the HIPAA release form. HIPAA is the law that says that you have rights of privacy over your medical information. The HIPAA release form can say that you want your medical information to be released to certain individuals. It's usually the individuals you write on your healthcare proxy. Now, if you have a healthcare proxy, why do you need a HIPAA form? The reason is because the healthcare proxy is only in effect if you become incapacitated as determined by a doctor. So let's say your daughter calls the doctor and says, my mom was in today and she said I could call you and find out what happened, but I want to know what's going on. I want to know what happened at her doctor's appointment. She can't remember what happened. I'm the healthcare proxy. Well, the doctor will tell the daughter, well, your mom's not incapacitated. She may not remember something, but that doesn't mean she's incapacitated, and therefore the healthcare proxy is not in effect. If that daughter also had a HIPAA release form, then she could receive that medical information regardless of whether or not her mother is incapacitated. So we like clients to have those as well. The last document that I referred to is a MOLST form, M-O-L-S-T, Medical Orders of Life-Sustaining Treatment. This is actually a physician's order similar to a DNR, a do not resuscitate order. They're signed by doctors, and the doctor will often review the MOLST form with the patient and go through and make very specific elections as to the type of treatment that the patient does or does not want as they reach the end of life. This is often a document that's signed as people are older and their health is failing, or if they have a specific diagnosis. It talks about when they want to be brought to the hospital, when they don't want to be brought to the hospital, etc. It's signed by the patient as well as the doctor, and therefore it's not a form that we fill out with clients. We just tell them about it, and they should speak to their doctor about if it's the proper time for them to be signing that document. The next document I'm going to talk about is the power of attorney. That's the one that could be signed by the governor any minute now for a new power of attorney law. A power of attorney is, many people call us and say, my power of attorney doesn't say it's durable and I need one that's durable. New York state law says that all powers of attorney are durable unless they say they are not. And this is for documents signed after 2009 when there was a big change, the last big change, 2009, 2000, and then 2010 in the power of attorney law. So if your document says power of attorney, it is likely durable. You're going to want to have it checked by an attorney to make sure it was done properly, but it is likely a durable document unless it says it's not. Durable means that it's in effect now and it's in effect throughout any incapacity. So you want a durable power of attorney because you want it to be in effect if you do lose your mental capacity. A durable power of attorney says all different types of powers that your agent has. So when someone says to me, I'm power of attorney for so-and-so, can I do X or can I do Y? My answer is, let's look at the document, because the document specifically states what powers that agent has. And sometimes the individual signing the document, we call them the principal, picks and chooses what powers they want another person to have. And it might not be all of the powers that are standardly listed in the document. Beyond the standard list of powers, there's a modifications section, and we often add in many additional powers, especially for our clients who might be applying for Medicaid down the line. There's certain things that they may need their agents to do, like take distributions on retirement accounts, open up accounts, close accounts, create a trust. And so we want to make sure that the client has given that power if they intend for somebody to be able to handle those types of things for them in the future. The other thing that the current power of attorney document has is a statutory gifts rider. This is a document that says, that's attached to the back of the power of attorney. It has to be signed at the same time. And it says that your agent can transfer assets out of your name. And again, there's very specific parameters that can be put in as to how they can do so, or they could be put in more broadly. So not all powers of attorney are created equal. So you're definitely going to want to have your power of attorney reviewed to make sure that it's up to snuff. And especially in light of this new law, and we'll certainly be putting out more information if the law passes, if it's signed by the governor, which we anticipate it will be, as to how the power of attorney has changed. Part of what has changed is the signing requirements. Right now, it requires 2 witnesses and a notary. It's unclear how the new law is going to handle that, and so we're waiting on it. The next thing I want to talk about is a last will and testament. A last will and testament is a document that states your wishes. One of the biggest misconceptions that I hear when I speak with people is that they say, well, I have a last will and testament, so I don't need probate. You can't have probate without a last will and testament, and you can't have a last will and testament be followed without it going through probate. They go together. And so if you have a will, it's only worth the paper that it's written on until it properly goes through a court process called probate, in which the court is validating the will, making sure nobody's contesting the will and saying that it's not valid for some reason. And then the court says, yes, this is a valid document. Yes, this executor can be appointed, and appoints the executor to move forward with the estate. So it's very important to realize that having a will does not avoid probate. It creates probate. Now, probate happens no matter what, or a court process happens no matter what if you have assets in your sole name with no beneficiary. So for example, if I have an apartment that I own on my own, and then I have a joint bank account with another person, and I have an IRA where I've named a beneficiary, the IRA will go to the named beneficiary. The joint account will go to my joint account holder, but my will have to be probated for my apartment, which is in my sole name, to pass on to my beneficiaries. And so whether or not the will is probated is going to depend on how the assets are owned and held, and if there are beneficiaries written on them. Same example, but if I never signed a will, then my estate goes through what's called administration, which is a similar court process to probate, in which my apartment would then go to my legal next of kin. It could be a spouse and children if you have them. If you don't have those, it could be a parent. If your parents are deceased, it's your siblings, then your siblings' children, and so on and so forth. So it's very important to be creating a will, a healthcare proxy, a living will, a HIPAA release form, and a power of attorney, because having these documents in place gives you a little bit of control if you get to a point where you're either incapacitated or after death, and you obviously don't have control at that time. This is the bit of control that you can put forth when you are at least putting those in place that you trust. Certain people want to avoid probate because of the COVID concerns that I explained, with the courts being slow or shutting down, because they may have property in multiple states that requires probate in multiple states, or perhaps they have certain disabled beneficiaries, or they're disinheriting one of their natural heirs. And in those cases, many people want to create a trust, a revocable trust. A trust, really the main and most important purpose is to avoid probate. And so if you have a revocable trust, you would take assets and put them in the name of the trust now. So I, Britt Berner, would create the Britt Berner Revocable Trust. It's a document. The document, just like the power of attorney document, says the rules of the game. It says how my assets should be handled. I may be the trustee. I can control them while I'm alive, while I'm well. I would say who would control if I become incapacitated, who would be in control after my death, how I want things to be distributed. And then I would actually title things in the name of that trust. That apartment, I wouldn't own my apartment anymore. My trust would own my apartment. I wouldn't own my bank account. My trust would own my bank account. And then there's nothing in my sole name when I die, and it all passes through the trust. There's other types of trusts that can be created, and they can be done for all sorts of purposes, for Medicaid planning purposes, for estate tax purposes, and to protect life insurance proceeds. There's all sorts of types of trusts that can be created, and they all have different rules. And that's how you determine what that trust is going to do for you. And based on why you want a trust and what your estate planning goals are, an attorney can help you figure out what the right type of document is for you. And the last thing I want to talk about is, what are we thinking about with a new president, with a new administration? Now, there's two main things that relate to estate planning that we've heard about that might happen. They were, or that were proposals of the Biden campaign. One was an elimination of the step-up in basis for capital gains purposes at death. So let me give an example. If you buy a stock at $1 and 10 years later it's worth $100 and you sell it, then $99 is gain, and you would pay a certain income tax called a capital gains tax on that gain when that item is sold. The current law, and what I anticipate the law will remain, is that upon your death, if that $1 purchased stock is worth $100, it gets a new base value at my death. So if when I die, it's worth $100, then I pass it on to the next person I'm going to give it to at $100. And if they turn around and sell it for that same $100, unlike my $99 worth of gain, they don't have any gain because of that step up, and therefore there's no tax. There was a proposal during the election and during campaigning that step up be done away with, which would create taxes, capital gains taxes, regardless of whether it was sold before or after death. Now, in certain situations, if that law passes, some people may choose to sell that stock while they're alive and take some of the tax hit on their own rather than pass the whole tax hit on. Some people say, well, you know what, this is the same thing for a house. I was only holding on to this house so that because it had so much, it went so much up in value that I don't want my children to end up with a big tax on it. But if someone's going to pay the tax, then I really would rather downsize. So we might as well pay the tax now before it keeps going up, and I can downsize and live where I actually want to live. Some people may say, I don't care if the tax is, if I don't get that step up at death, I'm living here because this is my house and I want to live in it. And they might not change their plan. And so again, that's where it's going to depend what your goals are. You're going to sit down with an attorney and figure out what's best in your own situation. The other potential change is a decrease in the estate tax exemption. The estate tax exemption is over $11 million per person on the federal side and over $5.8 million on the New York State side. So that means that if I am a person who dies and I have $3 million in real estate and cash and other assets, and my total estate is $3 million, I'm under both thresholds and I don't owe any estate tax. There's no estate tax owed at my death. Again, another proposal during the election was that the estate tax exemptions be lowered. And if they are lowered, then there could potentially be more estates that are above the threshold and more estate tax revenue that's created. Now, if you take a new president and you add with that the enormous amount of money that our government has been spending on COVID, a lot of estate planning attorneys will tell you that they anticipate that this could really happen. and that reduction in the estate tax exemption and an increase in the amount of estate tax paid is an easy way to raise revenue for a government that just expended and is still expending a lot of money on this COVID pandemic. And so, again, it's not necessarily something that's going to affect everybody, and it may not be something that you decide to change your plan for, but it's certainly a conversation you should be having so that you're not caught in a situation where you are paying taxes or your estate's paying taxes upon your death that you didn't anticipate would be paid. And you want to make sure you're leaving your beneficiaries in the best situation possible where they can meet all the obligations that they have to of your estate. I'm going to stop now and take any questions that anyone may have. We have one question. Can you have a revocable trust? Anybody can create a revocable trust, and that was the trust I used in my example, which avoids probate. And what you would do is you would draft up a trust document with your attorney and put in all the terms that you want. And then you can put assets into once it's signed and created, you can have the trust own assets and avoid probate by doing so. Next question was, where do you get a HIPAA form? That's a good question. So the HIPAA release form, actually the state, I want to say the number is OCA 960. So first of all, a HIPAA form certainly can be given to you by your doctor. It can also be given to you in a hospital setting. And then yes, if you Google OCA 960, you can actually pull up a HIPAA release form. You can also get it on the State Department of Health website. Someone asked to go over the form names again quickly, right? So today I talked about a healthcare proxy. You can also get that from the New York State Department of Health website. A healthcare proxy, a living will. I'm sure there's living wills available if you Google. It doesn't have the same legal form or legal structure that the other documents have. So I don't know if there's a set form you can find online, but a living will just is a statement of your wishes. A healthcare proxy, a living will, a HIPAA release form, that's the Healthcare Information Patient Portability Act, I believe. I always forget the HIPAA stands for. And that's a HIPAA release form, which we just went over. I also spoke about a MOLST form, M-O-L-S-T, Medical Orders of Life-Sustaining Treatment. That's also Department of Health form, and it's very important that you do the original with your doctor. It's on a hot pink cardstock paper, and it has to be the original, and that will follow you. So if you're home and you go to the hospital and you go to rehab, it will follow you from place to place. I also talked about creating a revocable trust and a last will and testament, but those are not forms. Those are more documents that you would review your wishes with your attorney. Your attorney would draft up individually for you. The next one I see is if you have a revocable trust, you do not have to probate. So this is a very important distinction. If you have a revocable trust and you take the steps to have your assets be owned by that trust, then yes, you're correct. You do not have to probate, because probate only happens when you have assets in your sole name with no beneficiary. So if the assets are owned by your trust or have a joint owner or have a beneficiary, then there will be no probate of your will because there will be no assets that are required to go through that process. Thank you once again for joining us, and I look forward to seeing you at our next webinar, which I think Liz can tell us about.